Development is attorney and legal analyst Dina Dahl. Dina, we just heard Alex talk about the move to ask for more DNA from Heuermann. Why not work with the DNA samples that they already have? Why would they need more DNA?
Well, it's a great question. I mean, we know the only DNA sample they have of Mr. Heuermann himself is the one that they obtained with his pizza crust that he had thrown out. They use that because they don't need a search warrant to test DNA on an item that has been thrown out. But, this is going to be a serious case. He's being charged as of now with 3 murders, maybe even more. They don't want any wiggle room in something like DNA, which can be the whole linchpin of a case. So they want to have the DNA sampled in a way that's recorded at the time, so that way they can show the jury how clear the chain of custody is, and maybe the DNA from this pizza crust was more partial, and they want a more full sample as well.
Dina, I have to ask you, though, also, since Heuermann is in custody right now, and we know that we heard his defense attorney speak earlier this week, how many times can they, how can they properly prepare to defend him if the investigation continues in this way where they keep coming back with more and more and more?
I mean, this is not unusual, right? I mean, the prosecution, yes, this is an unusual case because of the number of victims that may or may not be linked to him. But it's not unusual that there is enough to charge somebody with a crime, but the investigation continues and a case can get stronger. I mean, in this situation in New York, it's interesting about the DNA samples you mentioned. A lot of states, they just swab them immediately upon arrest. New York law is not like that. They're swabbed upon conviction. And that's why the prosecution here is asking for the swab kind of midway through after his arrest, but before his conviction. But under the 3-part test that the judge will apply, it's likely the judge will order him to give that sample.
And Dina, in that sample, since we know that different states have different rules around DNA, once that DNA is collected, is it then entered into a national database where investigators from other cities and municipalities can then compare that DNA from maybe open cases that they have?
I mean, that's typically what happens. Again, every jurisdiction is different here because it is, and before his conviction, where the New York law is really settled as to what happens to that DNA. But yes, it would be treated similar to the photograph that somebody takes or the fingerprinting that somebody takes. The Supreme Court has ruled that the collection of somebody's DNA is a similar identifying piece of evidence that the police can collect to identify the person who's being arrested. Here, again, it will also be used to bolster the prosecution's facts in this case.
Dina, one last question I have for you there, and I know this is getting ahead of things. Let's assume that this case continues to move forward, and at one point Heuermann were to say, okay, you've got me on these first 3. And can they offer him one of those opportunities to come clean with what else he may know so that he can possibly reduce any potential sentence?
Absolutely. I mean, every case, again, is different. But the more evidence that the prosecution has, the less of a likely they are to offer a kind of deal that a defendant would be willing to take. I mean, perhaps they'd be willing to do something like, take the death penalty off the table or something like that. And that's why these cases tend to go to trial, because although there's always a potential for a plea, the more victims involved and the more evidence the prosecution has, they're just not going to offer anything. Or if they do, it's not going to be kind of worth a defense willing to take the deal.
Dina Dahl, thank you so much.